Calvary, Albuquerque Incorporated, a religious institution, some sort of Christian worship church in New Mexico. And they want to have some pastor, this guy from South Africa, be their pastor. And as is permitted, and I learned this through the decision, you can come on a B1 visa to preach, check it out, before they go through the formal process of applying for an R1 religious visa. And he did that. And they loved him, and they're like, this is our guy. But then when he got back to South Africa, they gave him money. And they filed an affidavit in federal court that said they had a sincere religious belief that pastors should be paid for their work, which maybe that's true. I don't know how religious it is, but I think we can all agree with that. The problem is you can't get paid for work on a B1 as a pastor. So the state took the position that not only had he violated his status, but he did so knowingly, and it was fraud and blah, blah, blah. So they kept denying him. So they denied him his R1 visa, his permanent visa. And, maybe that was true. Maybe it wasn't. All you want to do is get into federal court and argue the merits of whether fraud was committed or not.
Yeah.
But the doctrine of consular non-reviewability will prevent you from really ever suing the Department of State for a denied visa. That's the Munoz decision from last term, for example, from the Supreme Court. Although, again, with the qualifier that I got a good decision for you next month on your show, so everybody just stay tuned. But can we get around the doctrine of consular non-reviewability? That is Calvary, Albuquerque. And the argument is based on the Religious Freedom Restoration Act, the RFRA, which that could be one of the exceptions. One of the exceptions to the doctrine of consular non-reviewability is if Congress has said so by law, that there's an exception. And here, they made the RFRA applicable to all, quote, all federal laws, end quote. And so that's what the dissent points out. All federal laws, that includes this doctrine of consular non-reviewability. This permits review of consular actions. If there has been a religious violation, which we can all agree there's a religious violation here, right? I mean, this church doesn't get their pastor. Now, whether or not that can then trump the INA and whether he possibly committed fraud, all of that. We're not even talking about the merits. We're just trying to get into court. That's the issue. The dissent would have said you can, but there's a lot of analysis about why it doesn't. Very well, reasoned 10th Circuit decision. But it's interesting, especially with the doctrine of consular non-reviewability, which is so difficult to get around. I would bring this RFRA argument into every circuit in the country, except the 10th Circuit where it's been rejected, where you have a religious violation, to try to get around the doctrine of consular non-reviewability. Because again, RFRA applies to all federal laws, end quote. That's a great textual argument. And how can it be that a Supreme Court created doctrine can trump not only a constitutional violation, but a religious constitutional violation that is then supported by a congressional statute in the RFRA? It's a good argument.